And the subject of our current panel is the mechanisms of control and supervision. Well, it depends what perspective you're actually looking at. Of decision-making processes during the military activity and the performance of those decisions during the military activity. I would briefly present you with those smaller prints. I will present in 5 minutes the scheme that the auditing procedures and control mechanisms that exist currently. I will not talk about the legal liabilities and what kind of procedures they should implement. This is an absolutely separate subject, and afterwards we'll have here a brief round between the speakers that will present us with different gaps that exist between supervision mechanisms and control mechanisms that and things that should be presented. One, two, one, two. טוב, זה לא ברור לי. And the main point of our investigation is actually Israeli Defense Army. And I put it here from the perspective of IDF. I have certain procedures of liabilities. And of course there is an internal committee, investigative committee of the Supreme Court. Tzal has a mechanism of legal control. The military attorney general office that's supposed to provide the consultation to the government. There should be a legal advisor of the General Forces Commander. He's supposed to provide him with a professional opinion of what is allowed, what is not allowed. He also have, of course, the legal authority to prosecute, including, of course, the General Commander. If there is a violation, the prosecution can be started against the General Forces Commander. He has an authority. And, of course, there is a question whether there's enough of independence in this context, whether we need to separate those units. It should be a consultation, it should be just a prosecution, and how it should be done. The Ministry of Defense is an entity of a regulation that is an initial regulator above the ADF that is supposed to create the policy and afterwards to implement the regulation to the extent of the performance of the policy. And the audit of the Ministry of Defense has a certain scope of legal authorities. It's called in Hebrew Chaz. Very often, that's how they call it in Hebrew. And again, there is, of course, a question of to what extent the legal consultation is provided to the Ministry of Defense. What is the role of the advisor? You have an obligation to do that, you're not allowed to do that, or whether it's just a consultation in a frame of recommendation. Okay, tell me what you need and I'll find a legal way to do that. There is, of course, a dispute. What is the role of the internal legal advice provided to IDF? The Ministry of Defense and IDF have controlling systems, internal audit systems of the Ministry of Defense, of the system of defense. Very interesting question whether internal audit is capable or should be capable of providing audit concerning other matters that are not financial, whether it's just a financial rule, or to what extent he is supposed to enter into the strategic matters and matters that are above the budgetary matters, whether there are procedures, sub-procedures do make sense, and what should be the controlling mechanism. And I would like to mention that we also have the state auditor. This particular system, IDF, the Ministry of Defense, are subjected to the Ministry of Defense, and we usually have the ex post criticism, when there is an ex post criticism, to what extent there is an understanding of lessons learned, what happens when the state auditor informs during. You have to remember that there's going to be an ex post criticism as well. Well, there is a very interesting mechanism of control and audit, and I would like to go to this script. There is also an investigative mechanism, and we actually exiting the Ministry of Defense and the IDF. There are also investigative committees, the governmental committee, there is the state committee, and there is a certain difference. Of course, the difference is important. There is internal investigative committee, Turkey committee, for example, was such an example. And we also have other famous committees, and we need to go back, and we don't have to look back into history. And we have different committees, and above those committees, there are also external committees. Goldstone Committee, for example, that has been founded during the Protective Age operation. That is operating now and is working currently. And this is a mechanism, by definition, this mechanism is ex post mechanism. What is very interesting in this mechanism of Turkey Committee, for example, that it presented recommendations of procedures as well. What kind of procedures should be introduced? What kind of procedures we need to have in place to notice for certain matters to be solved in the future? It's not just a method of operation of IDF and Ministry of Defense, but it's also the particular recommendations of how the auditing of IDF should work. One of the central auditing procedures on any entity is the legal advisor. Of course, there is a legal advisor to the government that is supposed to supervise and control general procedures of the system, including the government and including the military attorney. And if military attorney decided to reach a conclusion that was not justified by law, for example, the criminal prosecution was insufficient. That has been discussed in the Supreme Court, by the way. The question is what the legal advisor of the government should do in order to inform the military advisor that he is not using his consideration according to the law. To get within this particular structure of auditing, governmental auditing, there's certain processes of legislation, for example, the criminal department of the Supreme Court, of the special affairs of the Supreme Court, that some of the roles of this department is, for example, to make sure that the general system works according to the international law and complies with international law. It has other jobs as well, but this is one of the most significant roles. So there is an auditing and control supervision system, but there is a question in the context of protective edge, to what extent this mechanism works and performs, what we should improve, what were the failure points, the flow of information, for example, whether those dilemmas were presented in front of this mechanism, whether we should work on the level of procedures or do present the dilemmas. Okay, if there is no prohibition, please do not bother with the questions. Afterwards, ex post, we can discuss it. Whether I need to use my authority, for example, should I prosecute, then I'll have to talk to you. This is a very important matter that we need to discuss. And of course, we do have the courts. We do have the Supreme Court. I will not get into the division of authorities, but the Supreme Court is a well-known auditing and controlling mechanism. And of course, there is a whole legal system. I would not try to double dab into the system, but we're talking about the internal investigative committee or external committee of that sort here as well. The courts are international institution out there. I will not talk about the jurisdiction of ICC, whether they have universal authority or do not have universal jurisdiction authority. In countries, for example, Sharon's ordeal and Pinochet and UN, etc., those questions are being currently discussed in the academic world very extensively. I do not want to do that here, but the background, the certain shadow of existence of the international institutions, not just the criminal responsibility, we also have responsibility, civil responsibility. We'll talk about the rehabilitation in the context of civil responsibility. There are also questions of civil responsibility that are surfacing up. I would like to wrap it out in public. There is a very interesting question. To what extent the public, the civil society, should implement controlling and supervision mechanism, whether what is the public auditor, for example, all those public reports that are being, for example, the Society of Human Rights is writing, Human Rights Watch are writing a report. They're performing a role of an auditor, of a public auditor. He is not a state auditor, he is not an internal auditor, but he's writing a critical report. And this auditing report, what has been done, what should have been done, what is in compliance with international law, it's a part of its public discourse. I also have, for example, when the Human Rights writing reports, and not just writing reports, they are filing a plea. For example, when B'Tselem is turned into court, into Supreme Court for this matter or another, they are actually performing the civil duty, the civic duty during the protective age. We had less Supreme Court pleas that were filed. We had one about the protective devices in the south. And then there was a very interesting question, what is the difference between the gas masks that were distributed during the Gulf War in comparison to the protective shelters in the south that were not distributed? It's also a very interesting question. What's the difference between those two devices? And I'm actually finishing it because the civil society is also a very important part of the auditing procedures and mechanisms that exist. I presented quite a simplistic picture, of course, the mutual interaction between all those parties, because the auditor, the state auditor, is auditing IDF, and IDF's auditor is providing information to the Foreign Affairs and Defense Committee. And at the top of this pyramid, there is the Parliament, of course, the Knesset, the Committee of Foreign Affairs and Defense. They are supposed to be, well, for you it's trivial, of course, they are supposed to be those who are supposed to supervise the central supervision of the Ministry of Defense and Sahel as well. Or now, defense as a it's supposed to be, they're supposed to be role of a sovereign entity. Do they have this sovereignty? Do they have this tools that are supposed to provide them with ability? And when the Parliament is actually allowed to audit itself, how will they supervise the committees? They have, of course, different tools. Let's discuss those tools. Let's open the discussion from the perspective of the Parliament, because this is exactly where I think we should start. The matters of control, supervision, and mechanisms of audit. I would like to refer to what is important, what is good, what we should say improve, what is good enough, what is sufficient, and what is insufficient. Attorney Shoval, the microphone is yours. Thank you so much. I just think that we have here maybe a certain problem, and I think that
we have the Foreign Ministry. Let's just get into the sphere. The Knesset is the legislative and auditing principle, but the main work is conducted in the Knesset's main committees. In the Knesset, there are 12 permanent committees. We know, of course, about the Foreign and Defense Committee, the Budgetary Committee, and the special thing about the Foreign and Defense Committee is that it deals with secret matters. We have a subcommittee, and you all know the Intelligence Subcommittee. We know the Defense, the Security Subcommittee, etc. Regarding the significance of dealing with secret matters, I will later refer to the work of the Foreign and Affairs and Defense Committee's work. And we regulate not only the IDF and security forces, but also the government, the foreign ministry. The security forces are not only the IDF, however dominant it is. We have other security systems. What is regulation? What does the Foreign Affairs and Defense Committee do? Control is not only after affairs, but also during affairs, something I called real-time control and regulation. In order for the Foreign Affairs and Defense Committee's work to be effective, it is necessary that it cooperates with the security forces, because as opposed to other Knesset committees that can gain information, reach information through various means such as civil societies, media, academic research, the work in the Foreign Affairs and Defense Committee is based primarily on information that we get from security system. Therefore, I think the security system's duty to cooperate with us and provide us information is very important, because if it does not provide information that's supposed to be used for its regulation, it assaults the regulation authorities of the Knesset. Since the law says that any security action should be announced, and the Foreign Affairs and Defense Committee should be informed regarding any security measure, it enhances its ability to control and regulate the security system's actions. The work of the Foreign Affairs and Defense Committee has focused on two channels. On the one hand, we have approval authorities that the committee is brought with various pleas for approval, and I will later explain. And the second channel is controlling the security system and the political stratum. The situation, the Prime Minister or Minister of Defense can call an emergency situation or a special situation, and that allows the armies to take control and gives directions regarding school studies, regarding entrance to shelters. So once such an situation is brought before the committee can approve of such a situation where security forces have control, and it can disapprove of it. Also, we have the authority to approve or disapprove of recruitment of drafts on Tzav 8. We had difficulties with both aspects of information giving and of bringing various pleas to the approval of the committee. And my friends here from the committee are sitting here, and as opposed to the past, when the Foreign Affairs and Defense Committee would have given an unlimited approval for the announcement of a special security situation. This time we only gave an approval for four days on average. So thus we have forced the system to be more alert regarding the recruitment of draft soldiers in the Second Lebanese War and in the Oferet Metzuka, and at the beginning of the Protective Edge wars, the security forces asked for the recruitment of drafts. And in such cases, when a draft soldier receives a call for recruitment, he has to stop his work, his studies, his family life, and recruit to the army. During the war, and I don't remember who exactly said that, reported to the committee that over 80,000 draft soldiers were recruited. And I remember saying, that's not possible. We approved of the recruitment of 60,000 soldiers. And when we examined the situation, we discovered that without pre-announcement, the security forces changed the rules of the games and told us, no, if until today you were the ones to approve calls for recruitment in the framework of the 8th command, we no longer think that we need to come before you. What does the committee mind if somebody is in the army or not in the army? And for me, this is the point, because we're talking about a discourse of rights. When we call upon somebody to recruit to the army, we nationalize the individual for the benefit of the state, of the IDF. So there must be a balancing mechanism to confront such demands from the security forces. Thank you. The things that you've said, and we'll have time to get back to it, but the question arises, do you think, as follow-up, that you should have other tools? What you said is, I use whatever power I have in order to bring the security forces to the committee and behave nicely. But do you think you're in need of other tools? And one of the claims that have been brought up was fighting goals the alteration of fighting goals. Has the Foreign Affairs and Defense Committee been informed about it? Should it be informed that the warfare goals have been altered? So, okay, it's a war. We went to war for rackets, and then we found tunnels, and we changed the goals. Should the committee be informed? Should there be a discussion about it? And do you think you have the right tools to get the required cooperation from the system beyond side measures? The Foreign Affairs and Defense Committee also draws conclusions based on knowledge that during its work, routine work, it deals with. So the information and data foundation that the committee has is quite impressive, and it provides it with the tools to audit in retrospect processes and also things that happened in protective edge. And the committee had warned the security forces even before the protective edge. And in the framework of conclusions and assumption making, concluding, we formalize legal propositions such as inviting seniors to come to the committee. And by the way, the Prime Minister, as long as the committee asked to meet with the Prime Minister, there was no problem with it. There was quite a fertile discourse between us, and we're trying to reach a situation where seniors will come to the committee, and will be obligated to do that. The issue of the of the normative regulation of things, and it's quite probable that this will not be the last war. And we have a special situation where the system, we will need to receive. I'm sorry. We will later discuss how we provide reimbursements for citizens who suffered from indirect damages. And I believe the tax authority people will have something to say about that. And I would like to quickly turn to discuss the way in which the system should assimilate conclusions and lessons learned. The Turkle report, which we'll focus upon later. One of the things that was said, that there should be a body that will provide and assimilate the international law and controls which are more sensitive to the international law. Within the prosecution, I want to ask Dr. Gilad Noam, what is the way in which you see, from your perspective, to what extent do you think that a protective edge provided you with the tools you need, or whether you need further tools in terms of procedure and legislation to ensure better processes? Thank you. I regret that I will have to leave before the panel will be completed, and sadly I will miss some of the discussion. A bit of background, although Professor Deutsch should have presented the Turkle Commission, and I would have had to discuss the implementation, but perhaps we're changing the right order. But first of all, I will just generally say I don't see it as my job here to talk about the Turkle Commission, but just for you to understand from where we're coming, the Turkle Commission is an independent public commission that was established in order to examine the float to Gaza in 2010, and it was headed by the former Judge Turkle, Professor Miguel Deutsch, who is here with us, and foreign advisors, and later Professor Timothy Mikoma and others. What is interesting, and that has evaded the public discussion in Israel, is that the Commission has actually conducted two missions. One is the investigation of the flotilla, and the second, the examination whether the investigation mechanism regarding conclusion making regarding the flotilla event and general events matches the duties of Israel, the Israeli state, in accordance with the international law. The Commission determined that the investigative mechanisms normally comply with the Israeli state's duties towards the international law, but on various aspects there is place for improvement, and therefore it concluded 18 recommendations for improvements. The Commission concluded by saying, this is not to say that particular flaws have been conducted, but that there are to be further improvements to procedures. And I will try to focus. First of all, since we're short in time, I will not get into details, what's our department, but our department was established before the flotilla, before the Turco Commission, as part of a general trend and understanding of the system that we should, if we refer to the diagram from before, the understanding that Israel is not working in a void, in an empty void, and this diagram, if you would like, includes already controlling mechanisms, but we are living in a world of international law. Some people see it as something that the state of Israel should combat. I personally don't see it that way, although, yes, sometimes we are in a legislative war. But this is a given situation in which Israel should act, and it has many advantages. And I think the Turco Commission is a good example for the understanding of Israel and later of the Commission, of the requirement and need to work according to the international law. And I want to state that the second report of the Commission that dealt with general investigative procedures was published in 2013, and one of the last recommendation was to establish a commission that will deal with the implementation of these recommendations, and that was done. The government has established a commission headed by Dr. Yosef Chechanover and various senior colonels, representative of the Ministry of Security, legal advisors to the government, investigative factors. This team is sitting and acting in a very intensive manner, and I know that personally. Again, my ability to get into details here or report the team's work is naturally limited. Very soon, at the beginning of 2015, the team is due to present its recommendations to the government. They've been working very intensively, involving very senior professional factors from every stratum. We've been sitting long hours, debating questions that pertain to the application of the Turco Commission's recommendations, and I will refer to recommendations that have more to do with the Ministry of Law. But before that, I will say something general, and that has to do with the framework of the Turco Commission, which I talked about beforehand. Do we have the tools? My answer is definitely yes. Are we in the midst of a process that at its end we will get better? And my answer is definitely yes. How have things been implemented during a protective edge? And that we will be able to discuss later. But from our perspective, we have been very much involved in these things, and things have been implemented and have been assimilated even beforehand, before the protective edge. An important part of the Turco Commission's work was found expression in the conduct of all factors during protective edge. And before I refer specifically to recommendations that pertain to the Ministry of Law, the question is whether and how recommendations are being implemented do not only have to do with, yes, we can mark V on this and that recommendation. It refers to the general and overall conduct in terms of international law. And we always ask, wait a minute, Turco Commission recommended to act this way and that way, and we have been definitely directing our conduct according to its recommendation. And I have no doubt that within the following years, civil society will do its work dutifully. But our test will not be, sometimes the test is institutionalized and technical, but it is mostly an essential question. And there I think we have been seeing improvement. Sadly, I'm very limited in what I can say because the team is still at work, and within a few months it is due to submit its recommendations to the Prime Minister. But one of these recommendations is taking the during 2013, one of Turco's commissions was to transfer a certain role within security forces into the Prime Minister's department. It wasn't simple, but as of today, this function, sorry, not the Prime Minister's, but the legal department. The central IDF prosecutor, further recommendations of that have been implemented and that we can see happening within the IDF, I cannot talk about, but I will just refer shortly. The first and second recommendations of the Turco Commission refer to legislation. These recommendations require that in order to comply with international law, legislation should be enacted in order to allow effective penalties to people who perform international violations. In order to avoid certain gaps, it is better to enact and allow penalties within the law to crimes that violate the international law. What I can say, again, within the limitation, is that I personally and many others within our system in the Ministry of Law have been putting long hours, legislation, and we're not even there yet. We're just considering whether there's a need of legislation and which kind of legislation we will recommend. And of course, such a recommendation will have to go through many other mechanisms. And this is tightly accompanied by the implementation team. And we have been putting many hours to detect where are the gaps, how we should answer the gaps, in which legislative manners, in which normative environment we should enact this and that in legislation, such criminal legislation, complex questions that pertain to the international law. And the bottom line, will be legislation, will not be legislation, that's less relevant. This work has been generating a certain sense of commitment within the system and an understanding that we are living today in a different world, a world of international law. We should be looking at ourselves, examining ourselves, constantly, and this is a very long process. And assuming there will be legislation in such complex affairs, and it will not happen within a day, a month, and even a year. But the internal processes and thought put into this issue, we can only thank the Turco Commission that, for putting these things in front of us. Thank you. You've discussed various factors, the way Turco Commission has been operating. That's very interesting. The relation between law and society, because the Turco Commission did not enact, it only submitted a recommendations report, and I would only like to shortly respond. You talked about the responsibility of commanders, and we will talk about it, but two small comments. Pay attention to the response of IDF within the framework of the Operation Protective Edge. I think the expression was legislative terror. These attorneys who fought against us with legislative terror prevented from us to properly respond to the security threats. So I just wanna mention this, but you have talked about photographs of people who were investigated by the Shabak. Around 200 people, according to reports in the media, were taken captive, perhaps, were arrested, let's say. I know it's a criminal language, were arrested and taken to investigation in Israel. And then we know there are court orders about the Commission Against Torture. Is this law against torture still relevant for these people when they're in Gaza? If we take these people to Israel, we are subject to a certain law, and then we get to Gaza, and we're subject to a different law and legislation. So that's a question. So that's regarding who is investigating and how things should be investigated within the Ministry of Law itself. And in order that you will have a chance to respond to this, we will turn to you, Professor Doinch, and maybe you want to refer to it as somebody who has been within Turco, within the commission or the entity. Would you like to respond to what has been said, including things that you have seen within Operation Protective Ed? Okay, regarding the last part, I can't respond, and I think I'll bore you in this respect. I won't talk about Protective Edge. I don't have information. I don't have the facts. I don't want to talk about something I don't know. I don't have any data about the processes in Operation Protective Edge, not regarding the investigation of it. So with your permission, I know maybe this is not exactly according to the original plan. I will suffice by talking about the recommendations of the Commission. And the problem was and is how within 10 minutes I can give you a sense of what went on through hundreds of hours with really a detailed and encompassing report. There's no doubt that has been great work put into this, and I'll try to say a few words about the process, the goals, the significances of the report, and then focus shortly on 2-3 points that were more debative, regarding which there is a particular problem regarding the gap between criminal investigations and security investigations, about legislative questions, about the independence of investigative entities within the IDF. I'll just choose 2 or 3 out of a large range of questions. I'll begin with 2 words on our authority that was given in a government decision that talked specifically about 2 aspects: the aspect of the specific event and the aspect of how Israel complies to the investigative procedures in terms of international law, regardless of the flotilla. And the second part had almost nothing to do with the flotilla. We have seen ourselves as trying to conduct a more encompassing role. We were accompanied by advisors from abroad, and were assisted by academics, civil rights entities. We had 6 professionals who provided documentary data about warfare measures in major states across the world, in such as U.S., England, France. And we confronted this data with what went on in Israel among the IDF, the police, the Shabak, and various entities and mechanisms of civil entities, not only security entities. And now the question arises whether the recommendations are vital in order to comply with warfare law or not. And that's not a simple question. The rules in this sense are not rules, but rather principles within the international law. Regarding the question how how one can examine claims regarding the violation of laws. Investigation has to be independent, effective, rapid, thorough, transparent. Most of the materials that the international law has in this respect are from the civil rights framework. And what we had done is take many rules that were formulated in the framework of civil rights and then try to interpret them in view of the humanitarian law. Now, of course, the government decides which recommendation it adopts and which it doesn't. But it's a certain saying, can anything that the Commission has said, from it can be inferred that we're saying that something had been done incorrectly? I can't say. There are various legitimate procedures, more legitimate, more or less worthy, but our recommendations tried to reach a certain idealization of the fulfillment of principles. Any way that is independent, transparent, etc., can be a legitimate way. Now, I would like to be more concrete and talk about three aspects. One issue is independence. One of the claims that were thrust upon the report is that you didn't go all the way to the right place, because it would have been right to recommend to pass investigation on IDF actions, to take this investigation out of the IDF, because of the claim that the IDF cannot properly regulate and investigate itself. Within the framework of the report, we conducted a sample, very limited sample of this. But the claim was that the principle of independence is not existing here, because the IDF cannot investigate itself. Now, the international law does not obligate the independence, that the security force will not self investigate. But in 3 of the states that we have examined have internal security forces investigations. So having an internal investigation is not to say that the investigation is not independent. Now, of course, we have to institute mechanisms that will ensure that an internal investigation will be independent. The senior attorney in the IDF is not subjugated to the Great Army Commander, but to the Prime Minister. So we wanted to enforce this by saying that he will be appointed by the Minister of Defense with a recommendation from the Prime Minister, and thus we will hopefully improve his independence by 2 procedural aspects. One is limitation of time. We didn't want the Attorney General in the Army to be his appointment to be dependent on Army considerations. The second aspect is rank. We didn't want his rank to be dependent on security forces considerations. So that he cannot gain anything by giving favor to senior commanders. Now, another problematic question is that is the multiple hats of the Attorney General. He's also an assistant and counsel to the government. And as we know, there are some approaches that claim the roles of the Attorney General to the Army should be separated. Now, the Attorney General. I'm sorry. He who, sorry. What we have recommended is to strengthen the independence of the Attorney General that will be appointed by the Minister of Defense and a committee, and will be as I said, permanently ranked. Regarding the multiple hats, this should be solved specifically, but not generally. There are many recommendations that we will not talk about, and I think are very important, such as the recommendation to limit the time frame for opening investigations, to determine a time limit to the investigation in itself, solutions regarding reportage, documentation. I believe that these recommendations can significantly improve the situation. And as I said, I'll talk about two further points. One is very important: the relation between operative investigations and the decision to initiate a criminal investigation. When we published the report, and I have no information about what happened afterwards, on February 1st, 2013, the Attorney General will decide whether to open a criminal investigation only after he receives all the data, only after he receives the conclusions of an operational investigation. An operational investigation's purpose is to conclude operational conclusions to prevent the future events, but it has nothing to do with a criminal investigation, and it is not conducted as a criminal investigation. It does not strive to reach the truth in the sense of criminal liability. And this procedure meant that there is a long time before the Attorney General could decide to open a criminal investigation. And of course, because the Attorney General would have to consult with the operational investigator. So we recommended that these two processes should not be dependent, and that the Attorney General would not have to consult with the operational investigator, because these two processes have nothing to do with each other. So we said it is not right to see the results of an operational investigation as a basis for a criminal investigation. And we thought that other people should deal with the criminal questions. A team of professionals, independent legal advisors who can do the work while the operational investigation is taking place. The question arises: how much is it possible I'm sorry, I think the international laws answer in these cases the security benefits should be measured against the potential damage to criminal investigation. A last word about legislation regarding violation of warfare law. I think there is a problem in this respect, which may be manifested in certain circumstances and not in others. But the problem is that criminal legislation does not always comply with the required legislation in the field of warfare. In most states, adopt the legislation regarding violation of warfare law. They adopt it within criminal law. But there are legislative gaps, and rights organizations have also submitted papers regarding this, and also academics. There's a problem if we'll take one example in the sense of collective punishment. Take this issue, which is a violation of warfare laws. I can't see any criminal offense in the Israeli legislation that says that collective punishment is a criminal offense. It is, of course, a violation of civil rights. It is, of course, offensive towards human life and damages, but it's not the same thing. It has nothing to do with economic mass punishment, and I think this should be solved with legislation. And same goes to the liability of commanders and officers. I think in this respect we have significant gaps, and we'll finish with this. If we take the issue of liability of commanders, there is direct liability, but when we talked about the international law in this respect, we don't only talk, we talk in fact about direct liability for not taking all the required mechanisms to prevent the violation of warfare laws, and in order to enable the investigation of such violations. And I can't see that in the Israeli law today there is any reference to this. And I will stop here. Actually, I'm in an embarrassing situation. I mean, Professor Deutsch has invested thousands of hours in the report, and I only a few dozens. And I have, however, talked before the commission, but we didn't have time to discuss. But anyways, I will say what I wanted to say rather than debating with Professor Deutsch, because I don't think it's the right place, and I don't know if the audience will be interested in such a debate. So I resist my urge to confront Professor Deutsch. I was wondering whether to use the presentation, but first of all, I want to... Wait a minute. There is something missing here. You didn't even write it. There, the Army law that says that the whole security system should be subject to the authority of the government. But you don't have the government at all. And I think I know why. I don't know if it's for the benefit of, and I don't know if you'll get this on record because of my writing, but I will try to do a little taxonomy here. We should differentiate between at least two kinds of distinctions. One is between the issue of decision making, who is making a decision in various respects, in security forces, who decides to go to an operation, who decides the budget, and between a critical question that we deal with, and that is, what are the legal regulations that apply to decision making? And a further analytical distinction between controlling and governing, or regulating and governing. When we talk about controlling security decisions, we have a law here. The political forces have control over security forces. Now, that is very problematic. And we talked about the regulation upon decision making. Are decisions made according to regulations? But what we're looking here is to see whether it is effective. The control of the political or civilian will over the security forces, whether it is done properly. And again, we are getting to legislation looking for something else. We want the security forces system to be independent because we have the law and there are rules that they should guide, and not the political system, because sometimes these rules contrast what the political system wants. So one of the central principal foundations of investigation is independence. You cannot subjugate it yourself to a political system that has other goals, like winning the war. You don't subjugate your investigation to such interests. And I think this will help me in the next 5 minutes, because the question is, how should an investigation be conducted within the army? We can look at it from two perspectives. We can ask, who should investigate? And then some states in the world, and I agree, that some states says that the civilians should investigate because the army cannot investigate it itself, and that's the right way to subjugate the army to law, and that's the way to make sure that the army is subject to the law, by taking the power of investigation out of its hand. And then there is a question of, in order to verify the willingness of the investigative system, how much do we need a civilian control over it? How can we provide the Attorney General with enough independence so that he can investigate senior officers, commanders? And I think in Israel, a decision has been made, and I think it's legitimate, that in terms of investigations, that's in the hand of the army. Now we have the question, or one of the questions that the Turco Commission has dealt with, among many others, is which civilian system is appropriate to regulate and supervise this investigation in order to ensure that the Attorney General does his work properly. And not only that, but also to support him against the security forces. And of course, there are systems. We have the legal advisor to the government, and we'll get back to it. Should we say? We have a Supreme Court that in Israel is a supportive system. Are these systems appropriate? My opinion was, and I think is, that these systems are not sufficient in the sense that the legal advisor to the government, as Gilad went, but and we cannot praise him. We can praise him now. Before the department within the Ministry of Law that performs important functions of supervision. How much before that there was sufficient control? There was, but it was limited of the legal advisor to the army. Most of the knowledge was at the hands of the army, and even the Supreme Court, which is a certain supervising body entity, that's limited. And we also know that the Supreme Court itself said that it doesn't want to supervise. The Supreme Court said, I'm not the right entity to do this job. So what is the right civilian supervision? And in this sense, there are two approaches, and to a certain extent, one says, and that's maybe civil rights organizations that they said, listen, you can't do this work as it needs doing. So there's nothing else to do but establish international commissions. You don't know how to supervise the investigation properly, and therefore the International Committee will have to pressure you in order to make things happen. There is an intermediate approach. I think the Turco Commission's recommendations, which are not far from my own recommendations, is that there must be a way in which the Israeli public will know not only to say, okay, the Attorney General does what he does and we believe him, and that's where we've finished with thinking about the question that is interesting to us, whether really the legal questions have been examined. There must be ways to supervise this issue, and in this respect there are various models, and I say that the Turco Commissions basically recommended providing more forces, more authorities to the legal advisor to the government, and I think it has to do with the strengthening of the legal system there. And there's another approach that says that, in fact, the idea that the Turco Commission, its first part, is not so bad as I thought. Now, I don't have time to get into it, but just in order to understand the model, the idea according to which, not on a one-time basis, you know, investigations always commissions are always established during international crisis. You need to investigate, and sometimes there are good conclusions, but the reason for establishing an investigative commission is because of international pressure. And I'm not saying this as criticism, but as praise to the commission. But what I'm saying is the idea that there should be civilian supervision, constant civilian supervision that provides criticism on what's going on in the army. And I think it's a good idea. And just one last sentence. You want to locate this permanent supervising entity within the Foreign Affairs and Defense Commission? You want to institute that a permanent commission that will investigate every security forces action or operation? Well, first of all, we have the state auditor, and he's been thinking like this. I'm not talking about an investigative entity. I'm talking about an auditing entity. It's not to be in the aftermath, but an ongoing, a constant entity. I don't want to get into this in 20 seconds. It's a great question, and I think I have the answers. But I just want to differentiate. We really need to be careful here. We're talking about violations of international law. The edge of the iceberg here is criminal violations, but that's only the edge. Maybe the Israeli state has been violating international law, not in matters in which we have criminal liabilities. We don't always have a criminal that we can point to. The system today is very criminal orientated. So, for example, if there is a violation, the question should be should we initiate a criminal investigation or not? But the system should be such that it will teach the IDF to not to violate international law, even in cases where there is not a criminal liability. And the system that I have proposed should have a lesson learning aspect that is not necessarily criminal. We should have a system that can think how not to violate international law, even if we don't have somebody sitting in jail afterwards for that. Thank you.
So I actually took it from you. I'm fortunately not using the microphone. So now we're ready. I would like to present what Professor Deutsch just said so politely as a response to the statement of Gilad, and he said, I am very, very much support the constitutional legislation and corrections. I would like to bet 100 shekels they will never happen. They will never do that. They will never change the main clauses, and I'll say something more provocative. And the very fact that they do not use the clause of criminal code, Israel is actually putting in danger our soldiers. The Israeli court is not wrong. The Israeli law is not wrong. And we're not wrong, really. If the Israeli soldier is shooting someone who is waving a white flag, if you do not find the body, and there can be actually the manslaughter or maybe an attack. But this soldier, even it will be proved that he actually shot on the white flag, this is illegal use of weapon. There was prevention of a felony that was included into the military law, and there is a bypass of such a change when they change the similar felony, prevention of the crime and prevention of the crime, and introduce it into the military law. We have different verdicts from 48 that are punishing soldiers and putting them long imprisonment since they didn't prevent rape or murder that has been performed by the commander. Today we cannot do that. We cannot actually punish them properly because by mistake they misused this correction. Today Israeli law presented it differently, and I can give you dozens of different cases that show that. So Israeli law, the way it is, it's really unsuitable, and the law to implement those military laws from the moral perspective, first of all, I think we all will agree that we need to fight the war crimes. Isn't that clear? And there was this whole concept, the idea, that is called proportional attitude, and the world will not evolve in our world if we will prove that we implement seriously the criminal international law. And in order to implement that on a serious level is to investigate and discover that there was no offense. But, of course, they will not look at our matters in a way that... And, of course, the whole very fact that this Israeli soldiers are now currently under suspicion in many different countries, since our system has no capability of actually setting for sure that they are not criminals, and in very few cases to actually prosecute them themselves. Do you know that we have to correct this law, and the current law is unsuitable? And I'll tell you why will it never happen. There are two reasons, by the way, and I'm very, very sorry. But you have a certain baby, and this baby is called military prosecution law, and you're supposed to maintain that law, and you're doing a very, very bad job doing that. I'll give you a few examples of things that are completely unrelated, that has nothing to do with military crimes or war crimes. There is a statutory rape for 20 years is the punishment, and those who have it under strict circumstances, this can be life in prison. But during the 60s, it has been said by law that everyone is sitting life imprisonment. It will be 20 years imprisonment. So basically, under certain circumstances for statutory rape, we have a possibility of punishing worse than prison. And in obedience to commands is, of course, a very severe offense in the military, or refusal to fulfill a command. And actually, there is an intention which is different between those two, and there is a maximum punishment that's also different. The intention has been counseled by the Israeli law in '67. We had 20 years ago. There's 20 years. That the main difference between those offenses is the punishment, but not the intent. And this is the first initial reason, and this is actually something that has been printed by Israeli government, and was a wonderful law. And I can show you the protocol of those committees, the committee on the investigation of the military law that was begging, and others that prepared a wonderful law. And since then, it's rusting and is not being in use, and this is one of the reasons. Therefore, I do not have significant expectations. In addition, there is also a political reason. I do not really see when the public will compliment the parliament for actually legislating law against the criminal against military crimes. Because of the fear of the headline in the newspaper that will not well accepted by Israeli public, Israeli parliament members are putting in danger Israeli soldiers all over the world. Well, let's listen to the different statements of the army, maybe. Let's talk to Ronnie Katzer. First of all, I would like to talk about the protective age connection. We a little bit forgot about our main topic, but let's go, if you can, to the protective age, to the investigations and the committees that we had. Well, first of all, thank you for the possibility of being part of this interesting panel. My name is Ronnie Katzer, and today I'm the head of the Legislation and Constitutional Department in the Military Attorney Office. As part of it, you will definitely hear about the next panel, but here I'm from my previous role, and this is our target. And was part of it for more than 3 years, and we worked a lot on that matter. And for a more practical level, I must tell you that, unfortunately, I couldn't be here since the morning, but I want to talk about the protective. Well, we talked about additional aspects. Well, what was really interesting before we actually started the panel, why do we have it here? So you don't have to prepare the lecture. So I didn't prepare the lecture because it's a panel, but then they said that I have to talk about certain points of improvement. And of course we have here different points that we can improve. So, okay, let's talk about those points. And I would like to use this right, being almost the last speaker, to respond to a few things that were recently put up. And I would like to tell you something, that first of all, I would like to start with matters for improvement. We would like to do what we're doing better. And we're doing that constantly. And this report is well, we're talking about the part that is providing us with theoretical manual of how can we actually open those investigations. And this is a comparison of a very thorough comparison of militaries abroad. And we're talking about the possibility of recommendations. So let's talk about the third part that was founded on a certain sampling of random cases that has been performed by the General Attorney, Military General Attorney. And we have here a representative of the Military General Attorney Office. And the point is that this report has been published in 2013, this random sampling. The last cases that we were conveyed to the committee during the summer of 2011. And those cases were from 2007 to 2006. So the review that we're receiving here in Turkey is quite correct logically, but less relevant theoretically. Well, when we talk about the corrections of the report, what I'm actually intending to state here, this is about all the elements that the committee referred to. Recommendations, the wait of period of time before opening of investigation. There were certain periods of time when time frames of opening investigation were really a few months, and even above that, it has been very limited on initiative of our office. And now we talk about brief periods of time that are not exceeding 3 months. I'll explain to you what is the logic. And there were improvement in different procedures, there is specialization in investigation, and it has been done based on initiative of Military Attorney General Office. There is, of course, room to improve, and we did implement the Turkish Committee recommendation, and our office actually sees it as an opportunity. Since the recommendation for us were quite impressive to learn, to study, to understand things that maybe we saw differently. And we need to do them in a different manner. But from the other hand, we needed to understand it better, and that's what we do actually following the committee, headed by Mr. Chahanover. And we have to say that one of the recommendations of the Turkish committee was to actually find such a committee. And we need to do that and to implement that. When it has been said in the Turkey committee that it has to be performed in a number of procedures, we need to understand which procedures we need to go through on our way to this particular objective. One of the most important recommendations that were quite a good example of dealings we had with Turkey committee in the protective age it has been expressed. There was the recommendation number 5 of the factual estimation as an additional tool. Factual estimate, that is an additional tool for us, in addition to the toolkit we have. There are good tools, as I mentioned, in the Turkey committee in order to estimate factual plot for the limited investigation, but Turkey committee added an additional tool which is unique, which is very different, to found the team with an investigator commander and a legal expert. It includes a legal expert. It's actually above the criminal investigation. We're asking here for something that is more excessive, and it's very, very different. And this is the Australian model that we're using, which is a bit different because we talk about the tool for the commander, not for the Attorney General. It's not for us. And here, trying to implement, we talk about different various points that we can use as immunity for such a team. And it's a very important matter. At the moment, I do not have an immunity in the Israeli legal method. And I can mention that based on the teams of Hanover meetings we set together with former president of the Supreme Court, Mr. Shamgar, that said that we need to take those recommendations and to comply them with an existing legal method in Israel, because without an immunity, this is an investigation. If I'm approaching a soldier, I have to admit, I have to declare him all his rights that are provided to those who are under criminal investigation. And this is a matter of understanding. It does not serve the initial idea of this recommendation. Therefore, we try to find something that prevents us from doing that. And we did try to create this solution, and I will give you a little bit more detailed answer. But what I wanted to say is an additional point for improvement. I must admit that Professor Coyne really helped me here for everything he said. They targeted me to a particular point. That yes, I will say that using a certain slogan, an ability to distinguish between the main and important or not. Well, since you talk about that, we have to be very careful about the tendency that exists now, and we definitely do that a little bit when you are finishing an operation or a war, and that of course was an understanding of ours. It was a big operation, and everything that we're doing during this particular operation is under investigation of a criminal law. I think we have to be very careful about that. I will be very, very cautious now, but the very fact that the Ethical Committee, such as Idan, this is the discord, and this is a criminal discord, and there are two principles here, and the fact that the rules are still very rough, defined, they're not fine-tuned enough, it actually leaves us enough room to state here a very problematic point where we have too many tests to run, too many criminal investigations, too many points in criminal law field, and we need to be very careful, very cautious about that. And I would like to take that using those different mechanisms of control. On one hand, when we do supervise the implementation of the international law, I think that Noam talked about that this morning. First of all, it exists on the level of legal counseling, which is very tight in our case. And from the other aspect, I think maybe we forgot about it a little bit. Well, when we talk about the Supreme Court and this access and this whole plot and ordeal, well, and of course we have all the possibility of being under critique fire of the Supreme Court, like any other authority. I do not understand in light of history of the Supreme Court verdicts. And we are very transparent, and you're willing to try to look what we did actually recently. Where you come with this assumption that actually our office is not independent enough, is under conflict of interest. Our main rule, defined by law, by the way, in contradiction to the legal advisor to the government, we have an authority due to them and work independently, and would like to put the theory on the side. Professor Deutsch talked about that, and from practical perspective, I would like to tell you that we are definitely intend to see here as the Supreme Court as a very good authority in our case, and the Supreme Court never actually had their remarks to us. Of course, they found mistakes, as we did, as any other administrative authority. But when we talk about an institutional problem in our decisions, I don't think they ever had any remarks against in that context. When we talk about a very interesting point, there's certain aspects that do comply with international law, and I will talk about practice. I think it's a very good mechanism. I think it's a correct mechanism. I think we do deliver, and I think the example of protective law is a very good example. And quite a while after the end of the military activity, we are currently facing an unprecedented case. We had an initiative and we initiated a testing of 100 different events, and Ronan, a representative of our office, looked and located various cases from the media, from the foreign sites, complaints and various problematic points, and we started the testing process that has been performed by the factual estimation team that has been founded by the Commander General, and that included a number of teams that were led by senior officers, headed by general experts in investigative law. They were accompanied by the legal advisors, and those teams tested. They were disconnected. All the commanders that were on those teams, they were completely disconnected from the commanding chain of this operation and the cases. Those complaints were transferred to their testing, and some of those cases were already tested, and the decisions made by our office concerning some of the cases. There were also military police investigations that were opened in some of those cases. In this case, I would like to be very exact and tell you that never there was a situation in our office that it was a result of the review of a case. We open the criminal investigation when there is no operative explanation that is probable. For example, the certain cases there is a policy, of course. When we talk about any case of death, is immediately investigated by military police, and in some cases we have a possibility of let's say somebody has been injured during different public unrest in the Judea and Samaria. But this is our role, of course. In some cases, when it's violent demonstration, violent process, it can be when they're trying to bring an order back to the field. That can be dangerous, of course, but then there is a test and there is a certain military investigation that is conducted. But after Turkish committee, we do not rely only on military investigations in order to close a complaint. So this is an additional remark, but I would like to reply and to talk about, first of all, let's talk about legal terror. And I don't think that this term is really grew in the army. There was a very dangerous campaign here, and I think personally, I know this is my personal opinion, but I think it's a very dangerous campaign that connected between the legal activity and words like terror, which is unacceptable to me. And I can state very cautiously that there was a certain event that I think was a bit of a trigger to this particular story. And there was a statement of the commander of the military forces that of the air forces, and he said in certain circumstances, and although I am allowed to do that based on the international law, I'm allowed to attack. In certain cases, I refuse to do that for different considerations that he defined it as we want to be there where the international law is our threshold. It's not the high aspiration of us, but it's just a threshold. And he was there as a commander of air forces, and has been published in the newspaper that pilots from humanitarian considerations are not performing some of the attacks. The military is choosing to attack only to enter on with the infantry. But there was also an article that has been published in one of the newspapers, and that became a military response, but it wasn't a military, it wasn't a legal response actually. I think we have to be very exact. We're talking about a certain statement that the commander voiced, and I'm absolutely sure that he talked about it in the morning when Noam spoke. We haven't ever heard a statement of that sort. We never received a complaint from the IDF that there are any legal restrictions that prevent IDF's victory. What about arrests? Well, first of all, it's a very interesting question. When we talk about the illegal combats, and some of them are going to the criminal channels as well, I can tell you that one of the investigations that we opened was dedicated to the improper attitude towards the detainee in Gaza. This is one of the, I don't know whether we'll encounter the day when we'll fight the ticking bomb. That is not necessarily a ticking bomb based on the internal security investigation law. I'm not sure what we're going to do then, but I can tell you that from a practical perspective, that will never happen. Well, in name of Gilad, I would like to add another comment. Well, in his name, I would like to take this bet with if he's absolutely sure there's going to be legislation. Well, I think we're very much obliged and we're very much committed to this idea. But again, we need to understand this is a very complex matter, a very hard matter that from many different perspectives. And I also would like to put it on the table when we talk about different aspects. When the government is filing a law suggestion, they know what will happen after they file it, but they're not sure what will happen afterwards. But again, government is responsible, government knows what to do. And our intention is to understand this need that you're referring to. And it's well understood. We want to maintain that. And I have to tell you that as someone who is wearing the uniform, we never were part of those political games that took place. This is not the IDF. Maybe another factor in the Ministry of Defense, but it's definitely not the IDF, and I would like to wrap it up with that. We will hear now the civil society that has a last remark about everything that we would like to present here. Well, let's talk about the representatives of the academic world and people that are actually in the field. What would be our intentions? Well, this is quite a challenge to be the last speaker after lunch, which is quite challenging. Well, I have to say that someone has to say the last word, and this is quite new for the non-governmental organizations. Thank you for inviting me here. I'll try to be as brief as possible because, yes, it's very late and we don't have time. But quite a significant part of points that I wanted to attest to. When we talk about a different existing mechanism of control and audit, I would like to emphasize a few things that, for our understanding, are crucial. I will give you a few examples. What actually happened during the protective age in particular. I can tell you that concerning the Turkey Committee report, and I testified in front of the committee during the first part when I worked in the Gisha and Access NGO, and my idea there was actually to testify. The second part wasn't really well accepted by us, and we wrote a lot about it. Can you imagine the surprise when we received the second part of the report of the committee, which was a report that really adopted more or less majority of the decisive majority of all the statements, considering the liability to investigate, and presented quite a long line of different recommendations. That's a very good and very challenging against the system, of course. And we felt that majority of what we actually looked for is written there, black and white, by the committee itself, after the testing, after the governmental test and control. And don't try to celebrate our achievement. This is not about achievement, but I want to point out that there might be certain standard here that the committee took upon itself to develop. Yes, it's a question of international law. Of course, they took international law one step forward, and they did it very wisely, I think, and very thoroughly. And we saw that as a kind of model that we can use and use it in the future in order to compare the acts of IDF and the government within versus this particular model, to investigate how the army investigates itself and how the state is accepting different violations of military laws. And a very brief period of time afterwards, we heard seniors from the system repeating and quoting this sentence that has been quoted here again, that usually the system complies with different standards of international law, and that's how they learned that the system is kind of okay. And together with them, there were others that were standing there, and the people of academia, and they said, you know, in general, they comply with is quite a weak statement. What we actually need to pay attention to is the 18 recommendations that had quite a significant weight that were provided there in order to really bring the system to the state of compliance that is much more improved. And we heard what Deutsch said before, Professor Deutsch said before, that it's a very significant question whether the implementation of the recommendation is mandatory in order to comply with international standards or not. And I think, to my opinion, from where I'm actually looking at, I think in many cases, yes, they are mandatory. Otherwise, we will not comply with international law requirements. Yes, I will touch a few points here. When we talk about the operational investigations, and Turkey had a very firm statement about that. Yeah, there are certain improvements that already occurred, and Ronnie mentioned that. But we actually don't know enough about that, because those teams, that testing teams or estimate teams that work within the military general office, the only thing we know about them, that is a certain mechanism that is headed by General Tivon. Tivon was his name, right? And this is under him we have 6 different teams. We don't know anything about that. We don't know the scope of the authority. We don't know the scope of the jurisdiction. We don't know how they work. What's the method of operation? We don't know how they convey their conclusions and recommendations. Further, what kind of way they have in the decision of the general attorney whether to open the criminal investigation or not. And the very fact that we barely know, and we don't barely have information about those committees, and regardless of the fact that we ask again and again, our organization and other organizations ask again and again, and they try for more than a year to try to discuss which Hanover committee that is responsible for implementations of Turkey's committee. We know nothing, and this is quite a sign that there is a big problem with transparency in the system, and this is a problem that is provokes our concern, tremendous concern actually, when we talk about the democracy and transparency and the civil society in our name, in the name of Israel Republic. We need to look into it, to review the system, whether it complies with international standards. What are the human rights violations that exist? It's very hard for us to do that in a situation in which we don't know what our system actually does. And the transparency rules that it's supposed to implement on the investigation themselves are not even part of the foundation of the mechanism. I think it's very problematic. Well, this is one matter, and I think it's very, very important. And there's also this question concerning the obligations of disclosure of the system during the military activity of the protective age operation. We ask again and again, repeatedly, are responsible from our organization and other organizations of human rights. And the public as well wanted to know what exactly is being done, based on which standard they work, not just legal standard, but general standards. What is the attack policy, for example? How do they choose what to choose? What is the legitimate objective? How do they choose this particular perspective? I'm not even talking about the theoretical questions. Real questions that in the end of the day do change the way the military activity actually looks, and something that can influence. We saw here certain aspects that arouse a lot of questions. There is no legal standard what should be exposed by the army during their military activity towards the public and towards the civil society, civil sector, whether they have to report with the policy and how they implement this policy. But I think that this is something that should be definitely examined in depth and profoundly, and to deepen the discussion between the system and the civil society, and the people of academic world should definitely join that matter, I think. And I think the most important part, and I think we have here a certain perspective that is very, very important, and it has been mentioned already, so I will definitely touch this point. I think the most important matter here in this case is the, first of all, investigations of the policies. When we talk about all the mechanism and the mechanism we discussed here, they talk about 2 matters. First of all, the policy of the decision-making processes, which is done by the parliament and by the auditor, the state auditor. And that's what the Supreme Court does in certain cases. And this is one of the cases. So this is a decision-making process that has been examined, that the supervision on the decision-making process is also, but there also an implementation of the policy. Policy implementation by the soldiers, usually soldiers of a low rank that are in the field, and usually the military system and the investigation within the military attorney office, whether they complied with the military law. whether they implemented the instructions and orders that are given them from above, from top to bottom. And this is done by the military attorney and the military police. They do that to a certain extent. It's done by to certain degrees of success. There are certain fields where they're more successful, where they're less successful. I will not get into it. There's structural problems with that, of course. But again, this is something that I will put aside. I'm less bothered by the question, and this is an important question, of policies. Policies in different standards and the responsibility of the commanding officers and the political officers of building of such a policy of attack. And today we have, and Professor Cohen talked about it, and Professor Deutsch talked about it as well, we do not have a mechanism of testing and control of the governmental authorities and military authorities. When we use a Hannibal procedure during the Black Friday in Rafah, the level of testing that is performed by the military attorney is only the compliance of the forces in the field to the instructions provided them from above. There is no any testing of the Hannibal procedure. When Tzal works with the Havel Tiroli in Sajia, in the municipal, very crowded territory, and herds, hundreds of citizens, there is absolutely no level of testing on the principal level. What is the process of decision making? No one. We don't have any particular meaning. Whether it's reasonable to use artillery fire in a crowded residential area, whether it's a legitimate thing or not, whether the forces that are using this particular fire are using it within compliance with the international law. We don't have absolutely no any authority here. What is the objectives when the army is bombing from above the houses of Hamas seniors, and they are bombing medical facilities maybe, or cafes? What makes those sites to military objectives? So what is the policy? And how is it set? And how is it being implemented? Again, on various levels. And when we talk about the policy, as a civil society, we're very much bothered by the way that State of Israel investigating its own work and implementation of international law. For us, those questions are very heavy. They're very important. I just want to notice a few matters. I'm not talking in the name of the civil society in general. I'm not talking about the international society. We're interested in what's going on in Israel. We are working in Israel. We care about Israel. We want to know what's going on here. We are not addressing international entities to start and to investigate. What is important for us? We do not talk about different implementations from abroad. What is important for us is to investigate by ourselves to profound levels. Thank you so much. We just finished with different matters. We started with 4:15. Now we are a little bit late. We started late as well, but we have so many questions to discuss and people that would like to respond. But we also have an international law that actually says whether we can prevent from you drinking coffee, which is also illegal by international law. But therefore, we'll say a few things in order to wrap it up. We saw here how important it is to analyze the question of the relationship between the institutional lesson. How is it being investigated and who is investigating that? There is a certain role of the parliament, and the role of the parliament is a decision-making process and the implementation process. And we ended the discussion with a request to someone out there that will test and examine the procedure itself. For example, the Hannibal procedure, the way it has been implemented while attacking the electricity station, as we mentioned in the beginning, we have the ratio between two of those matters, because very possibly that the existence of investigative mechanisms of that sort that are very crucially important paralyzes to a certain extent the development of the internal procedures and regulations that are supposed to be part of the auditing entity itself, for example, Minister of Defense, and under supervision of the Parliament. But there is certain problematic, unfulfilled relations that might be very positive, might be very negative, I'm sorry. Well, when IDF or Minister of Defense should prevent such a situation, actually to develop those procedures and to allow the Parliament to examine that in a way that not necessarily will cool off the criminal testing procedures or testing the liabilities. We need to be sure that the international law is compliant.